statute of probation says, no, let me stop there. She says that the original order doesn't approve it. I go, well, it doesn't disprove it. I said, they're not on our list. Who are you to say that? She says, the statute says you can't violate any federal laws. The probation statute. Which is standard language. I was like, I am not talking to you anymore. Because this is like just not even... And I'm thinking, we're at a place where this should be a little bit more. But you just see that it's so built into this. So they have... This is such a racket, Jeff, that what they do is they don't even put it on a piece of paper. They give you like a sticky, like you're going to peel it off of something. And I don't even know if they're going to put it on something, but I got like a piece of paper like it was like a name tag, like your name tag right there. It was that size. Written on it was 30 days in jail in red, X amount of dollars of fine, continues to use marijuana. Okay? So, and this is the document by which we're defending. It's not even like in a formal, it is there's nothing official about it all. So, she's scared out of her mind because they're just having their way with her, and she's, and I am not getting along with the probation officer, and I said to her, look, if we got to talk about it, and I got her ready, we went in there, and they called the case, and I knew that we would be able to adjourn it. The judge was going to give us a new date to come back, because we're entitled to an arraignment, a bond, and come back. And I go, Judge, so after you give us a date, I just do want to mention something. The document that we just arraigned on, a complaint, the show cause, whatever, is facially deficient because it alleged that she is testing positive for marijuana and doesn't recognize the fact that she's got a medical marijuana card. And by having that medical marijuana card, she's immune, as a matter of law, from these charges. She's got a card. She is entitled to engage in the medical use of marijuana, period. And she can't be punished. No judge likes to hear that. Approach the bench. I get one of those. So we go up there, and if I told you why, if I said to you, you would say, why was that judge off the bench for a couple of years? You would say, it's all showing itself as we approach the bench. I'm just saying, I can't even begin to tell you that it's like, but nevertheless, the probation department was there giving me lip, just continues to push on. The judge tried to tell me that it's illegal federally. I said, Judge, there's a case on this. It's called People versus Tierbeck. And besides, we are in state court. You may be a great federal judge one day, but here, now, in this court, Judge, we're supposed to, there's no federal indictment here. There's no federal VOP. You can tell me it's illegal federally, and if she's prosecuted in federal court, then we will not be raising the medical marijuana defense more likely than not. I mean, maybe we, still try it, but I won't expect it, still. So, and then they started with the letters. I'm like, Judge, I've never seen such well-written letters. Where do we? So the probation department was not letting up, and I finally said, I'll tell you, why don't you guys just close out? She's got a month left, and the probation officer says, okay, I'll agree to that, no jail time, but she's got to pay $25. Of course, we took it and we left, but it was just the final, and I say this, at this moment in time, they had completely stopped testing her for alcohol. I remind you that this was a alcohol-related driving offense. She kicked, they hadn't had a sip, and they stopped testing her. They were only testing her for marijuana, okay? And they're doing this ETG test, which is, so my point is, when you see the amount of money that she spent over this period of time, when they're testing her to bring her all the way up to that point, which at one point, they had her going 3 times a week, $30 a week, $120 a month. Who wants to spend that kind of money on that? All right? And they had to get the last $25 out of her. She was happy to leave. It was, believe me, to be over with that. And likewise, I mean, I could go on, but the point is that it's amazing the way that the racket is set up. I mean, when the judge wanted the approach, I think he didn't want people to hear what the law says, so they could say, me, or something, because no one's bringing it, I just couldn't believe what was taking place. The judge did not like that because they run this, and counsel people that come in here everyone's got a card. I'm like, okay, but this doctor signed his name to a certification. If there's an issue, the state of Michigan will take it up with the doctor. It's not for you to put your judgment there. Prove list. It was, and the gamesmanship that's played of the testing and what's allowed. I mean, the beginning part of the story was just a total disconnect of the original intention of what a probation sentence may be meaningful for, and why you may want to create requirements that, if able to abide by, would be meaningful for graduating or succeeding, one could say, by addressing the substance related to the crime, especially this alcohol related. Nothing to do with the medical marijuana that she was using, and overwhelming evidence about that. Now, the other question: what happens when someone has a marijuana case? I had this today where there was this disdain of the judge wanting to allow my client to remain on, HIDA status because he's 21 or younger, and to be able to receive a potential to successfully complete probation and have the charges completely dismissed off the record on this statute of Youthful Training Act. It was not a great case. There's several undercover deliveries to undercover police officers. It was in a house. So, but there's a challenge. The more challenge of the cases, those kind of deliveries. But as we stood there for elocution today, the judge was very skeptical of this 20-year-old's desire to want to use medical cannabis, while we're asking the court to look beyond the drug dealing, as he liked to categorize it, as the selling to these undercover police officers, which may never have taken place if they weren't, represent themselves as patients or whatnot. But putting that aside, the judge, you can imagine the mountain I thought I was climbing, We actually started talking about, well, what about his driving, counsel? And I said, well, what about his driving? What do you want to know? He's like, well, how about driving before I go to judge? Like, it's not like alcohol where it stays, there's a shooting up and a short period of time that you remain in that, and besides, doesn't use high-level THC, and that's not on this record, counsel. I don't even know what you're talking about. What are you talking about? But it's just fascinating. It's just, as we go forward here, and I know we have legalization on the forefront, I wonder how long it's going to be where people understand it to be what it is, and the system that is in charge of monitoring these things.
Not much longer.
Takes, and I guess if there was a reason to have a card still, it would be to
escape tax.
Well, I mean, if you are on probation, you could still argue that you instead of it just being accessible for recreational purposes.
It's your medicine.
It's a medicine. I'm not saying, but anyway, so I think it's kind of an outrageous system that we're in here, and when you step back and look at it, I was just watching how many people were there. I think they set a day aside which are exclusively for probation violations. I know that one of the trends in the court system is to try to move towards more equity courts. There's a veterans court that we're aware of. There are drug courts now. In fact, one of our cases, the judge talks about how the first and third week of every Wednesday is my drug court, and I can't tell you what a wonderful experience it is, because in their eyes, by putting them through these things and having people graduate, and gives them some kind of meaning that they've done something. But I don't know that that's always a solution. I mean, the idea that they're now beginning to utilize the court system in a public health way, where they're treating instead of encouraging, and that's been the new trend.
So is that how they hide the
Hugs, not jail.
They hide the jail numbers is by just getting everybody on the probation violation? Nobody goes to marijuana for jail, right?
Oh, that's
so it's all...
Yep, not until they violate their probation. Yep.
Very rare. It's rare. I mean, I think straight out of the box. I mean, it happens. There's judges that do that. I've seen it happen before. Less and less. And what a lot of people don't know, which is a important aspect of this, which is that even though marijuana is a Schedule I drug in Michigan, the only reason that it remains constitutional, according to the Michigan Supreme Court in the John Sinclair case, is that the punishment for the possession of marijuana, albeit a Schedule 1, is completely different than all other Schedule 1 drugs. The possession of marijuana is a 1-year misdemeanor.
Any other scheduled drugs, really? I mean,
All the other Schedule 1s are 4-year felonies
right.
for the possession. The delivery of marijuana is a 4-year felony. The manufacturing is a 4-year felony. Depending on the weight, it may increase. The delivery, manufacturer, possession to deliver, any of those other Schedule 1s are 20-year felonies. Okay, so the disparity there is... so when you say, do people really go... Because the guidelines don't call for it most of the time. You know, if it's somebody that there's additional charges, a gun at a house, which is not necessarily any more culpable, and those facts alone, you know, it could be someone with a Second Amendment right, a right to exercise their medical cannabis right to use. Nevertheless, I think those guidelines, because it finds itself on the grid at a, you know, not as a less serious felony that has less, you know, that is punished less. Those guidelines are always going to be on the lower end. I mean, first offense person with no significant instance is going to have a 0 to 3 month or 0 to 6 month or a couple counts of delivery, 0 to 9 months. Meaning the court's got the discretion of 0 days in jail, up to 9 months in jail, if they wanted to. That scoring on its face would be deemed the type of sentence that would call for community sanction, you know, some kind of local probation or county jail at the worst, okay? And but then they are on probation. If they continue to test, sometimes they will nail them, you know, and people will end up there, I think. But I think it also, as we know, and this has been one of the things associated with the propaganda machine of marijuana, that so many people are in treatment for marijuana. Look at these statistics. X amount of people last year got into treatment. Look at what they did over at, you know, this place and that place where they, you know, forced them into, prayed them into stop using cannabis. Just kidding. But the...
You know what the stick rates are for those programs?
The what rates?
The stick rates for those programs that the courts force.
Well, the reason why they do it is because they take the 7411. The courts have a program for possession type of offenses, which is first offense drug offenders.
And there's fees involved too, right?
It's not just that. It's the whole gamut.
Yeah.
That crime, and I don't, you know, I mean, if someone wants to do it, they're my client, fine. I mean, but they got to deal with it. I can't control a lot of that. You know, that's why, like, why would you?
A 7411 isn't necessarily a bad thing.
It's not a bad thing. I'm not knocking it. I'm saying, but if you've got a card, you should be pleading guilty to anything. You know, if you got a card, you got an affirmative defense. Right. You know, I'd rather. I mean, the alternative is you're going to be on probation. You get your finger in your bloodstream, and you get to. I don't know. It's you know it's unnecessary. They still have not figured out a way to treat the sentence and punishment of a medical marijuana patient or a technical violator of the MMA differently than all other crimes that come through their system. Still, 10 years into it, you'd think that they'd be able to say, okay, we have some of these people that are associated with our traditional business here in the district court. We got our domestic violence. We got our drunk driving. Second offenses, those are the big ones because that's a year in the county, and that's the highest offense we can do. And maybe a possession of marijuana, and then I get to suspend their license. That's the gamut of a district court judge's, most penal circumstances.
Well, maybe that's where the diversion should happen. Maybe upon arraignment, there should be, if somebody presents a valid card, a medical marijuana court. Only deals with medical marijuana patients and caregivers.
Well, that's a very good point, but I think what you're going to find, which is inherently problematic, and I still feel like this discussion is taboo in this court system. You may say it's because they haven't come around yet, or you may say it's because it's economically feasible to stand this way, or you may say, this is not my wonderful house. You may say, how did I get here? I'm kidding.
And we got here because it's Schedule 1.
I heard it.
Right. And we got here because it's Schedule 1. That's what they land on, isn't it? And the most telling thing is this. Here's a person, client you're talking about, that was about to complete 2 years. Now, 120 a month went to the testing. There was probably another 100 or some odd a month that went to the, what was she paying? $300, $400 a month?
Yes, and that's the point that I'm making. It is within that system that it generates all these resources